to discuss your experience with anyone. For the remaining jurors here, you have been passed at this time for cause, or any objections were overruled by the court, so you will be returning. We'll continue to question additional groups such as yours until we reach the necessary number of jurors for the attorneys to exercise their peremptory challenges. You're going to be instructed to contact the jury commissioner. We'll give you a card with his contact information. They'll be providing you additional instruction regarding when you will again be required to return, when we'll assemble the final group of jurors for peremptory challenges. While you are waiting for that, again, please bear in mind the court's admonishment to not discuss the case or investigate the case during this critical time frame, so that you can remain impartial in the case as we've previously determined. And if anybody is trying to contact you or for any improper communications, please note that and report that to the court. And I'll also have you complete that admonishment indicating that you have not researched or looked into the case since we last met, whenever that is, that you are instructed to return again. So that will conclude the voir dire for this particular group of jurors. Before they're dismissed with instructions to return, anything further from the state?
Nothing further, Your Honor.
Okay, from the defense?
No, Your Honor.
Okay, that will conclude this panel, and we'll take a recess here, and then we'll discuss our scheduling and where we stand for the day. I'll meet briefly with the trial court administration also on that issue, and we'll come back on the record here in about 15 minutes. Take a break.
All right, please.
All right, thank you. Please be seated. And before, again, we bring the next group in, we'll make sure to discuss with counsel scheduling and where things stand, and then we'll get this third group going as soon as we can. All right, thank you. We'll go back on the record now on case CR 22-21-1624, State versus Lori Vallow. This is the time we have set aside for juror voir dire. We are about to commence with our third group of proposed jurors in this matter. Given the scheduling of where we are, we've made some adjustments to the schedule. I'd like to start there, and I'll indicate that I held a sidebar with counsel off the record to discuss the scheduling of these remaining jurors for today. Counsel, you've been given a chart which would indicate our group 3. We had intended to try to get to a fourth group today, but we're not going to have time to do that, clearly. We have groups lined up for tomorrow. So the group 4 jurors for this afternoon on my list started with a number 1782, and then the number restarted again, but ending with a juror number 389. Hopefully we're all looking at the same group for organizational purposes, but my understanding is the parties agree that we can allow those jurors to be put on a standby status and released for the day. We'll finish up with group 3 today, and then if we need to, we can recall group 4 at a later date. Does the state agree and stipulate we can do that at this time?
Yes.
All right, does the defense agree as well?
Yes, Your Honor.
Okay, counsel, and I'll also just indicate on the record, given the random nature of how their juror numbers were assigned, does the state raise any objection to the manner in which we're seating or calling the jurors, given that we're going to change that schedule?
No.
Does the defense raise any objection to the manner or method in which we're impaneling or seating those jurors on that list?
No, Your Honor.
Okay, thank you for your cooperation on that, counsel. As I mentioned, then tomorrow we'll plan on doing 3 groups like we did today instead of 4 to allow adequate time for your voir dire. We'll have groups tomorrow tentatively scheduled for 9 o'clock, 11, and 2 o'clock, and we can discuss that more on the record tomorrow. With that in mind, then, we'll bring up our final group of jurors, Group 3, and have those jurors brought in at this time for voir dire. We are back on the record on case CR 22-21-1624, State versus Lori Vallow. The attorneys for the state are here present and the defense as well, along with the defendant. We're continuing voir dire examination of groups of jurors. The court at this time will conduct and allow parties to conduct voir dire examination of one more group this afternoon. Counsel, I've been handed the seating chart for this group, and to make sure everyone's on the same page, we should have jurors with numbers from 1106 to 1758. Does that comport with what the state's got?
Yes, Your Honor. It does appear maybe one juror is missing.
Okay. Do we have, we'll go ahead and take a roll call at this time then. Let me just cover a couple other preliminary matters. There is a courtroom conduct order in effect. These proceedings are being simulcast to 2 separate viewing locations, one in Ada, one in Madison County. The use of electronic devices to record or photograph or transmit any sounds or images from those viewing areas is prohibited by that order, and the bailiffs are authorized to confiscate any devices used to do so. I'll also note that the court received the juror affirmations from each of the jurors in this group, indicating that they've complied with the previous order once they were released after they completed their questionnaires. So we appreciate you following those orders and completing those affirmations. At this time then, I'll finally advise counsel again, remind you to only refer to jurors by their number, what we call the red card number, because that's the number on the red card that you have. And we'll take a roll call at this time to ensure who's here and determine who's not. So, Madam Clerk, if you would start with the roll call, starting on the front bottom row, lowest number, we'll go in ascending order to the second row.
When I call your juror number, if you could please answer off for the record. Juror 1226. Here. Juror 1133. Here. Juror 1210. Here. Juror 1238. Here. Juror 1266. Juror 1273. Juror 1276. Here. Juror 1323. Juror 1370. Here. Juror 1527. Here's the FTA. Juror 1569. Juror 1571. Juror 1589. Juror 1658. Juror 1758.
Okay, thank you all. If anyone is contacted or hears anything from Juror 1527, please advise the court. I will admonish that for their non-appearance, they could be subjected to contempt under Idaho statutes 7610 or 22085. We'll take that issue up at a later time with that juror who has failed to appear. Ladies and gentlemen, thank you for returning back this afternoon. We appreciate your patience. I know you've been here for some time. You've been recalled in this case as prospective jurors now before us. I'll reintroduce you quickly to the staff that's assisting today. I'm Judge Stephen Boyce from Fremont County, and I'm in charge of the courtroom in this trial. The court clerk seated to my right is Shannon Holstein, who keeps minutes of the trial proceedings and marks trial exhibits and administers oaths. There are bailiffs here assisting us, Deputies Ravello, Holmes, and Beish. They'll help with the courtroom order and assisting in moving the jury around. The court reporter, Patty Bath, takes a stenographic record of everything said in the proceedings, and then my staff attorney is Courtney Stallings, who's seated at the table over by the window, and she will assist me as needed with legal issues that may arise during the case. Each of you is qualified to serve as a juror of this court, and you've filled out a questionnaire that's now been reviewed by the court and the attorneys. This is the process of selecting 18 jurors altogether, which is 12 jurors and 6 alternates from among the group. At this time, we've already gone through the roll call and indicated we had one juror fail to appear. I'll again advise you of the jury selection process and reintroduce you to the parties and their lawyers and summarize briefly what the case is about. When I introduce an individual, please stand and then face the jury panel, then you can retake your seat. This case has been brought by the state of Idaho. I'll sometimes refer to them as the prosecution. The state's represented at this trial by Lindsay Blake, the prosecuting attorney for Fremont County, and by Rob Wood, the prosecuting attorney for Madison County, as well as Rachel Smith, special prosecutor appointed in this case. The defendant in this case is Lori Vallow Daybell, who's represented by her attorneys Jim Archibald and John Thomas. Thank you, counsel. This case is a criminal matter, which means that the defendant has been charged by the state of Idaho with a violation of the law. When you were last here to receive your questionnaires last week, I read in detail from the indictment the charges that have been filed in this case. I'll again reiterate a brief summary of what's been filed in the indictment in this case. With regard to the defendant, the state of Idaho has alleged that the defendant, Lori Vallow Daybell, committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception, count 2, first-degree murder, count 3, conspiracy to commit first-degree murder and grand theft by deception, count 4, first-degree murder, count 5, conspiracy to commit first-degree murder, and count 7, grand theft. The defendant has pled not guilty to all of the charges. And please remember, this is simply a description of the charge. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next address the juror's duty in this case. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I'll later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During the course of the trial, including the jury selection process, you're instructed that you are not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time then, I'll ask that the court clerk swear the entire jury panel for this voir dire examination. Ladies and gentlemen of the jury, if you would please stand and raise your right hand, I'll have you placed under oath.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
Thank you. You can be seated. Will the state stipulate that the jurors are now properly called, impaneled, and seated?
Yes.
Will the defense also stipulate that these jurors are properly called, impaneled, and seated?
Yes, Your Honor.
All right, thank you, counsel, for that. I'll next discuss the nature and purpose of voir dire. In this part of the jury selection, you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand that this questioning is not for the purpose of prying into your affairs for personal reasons, but is only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand. And at this stage also, I'd say raise that red card, which helps us identify who you are. And when you're called upon to speak also, you can just identify yourself by raising that card, please. These proceedings are being recorded stenographically, so when asked a question, please make a verbal response such as yes or no. Try to avoid saying or nodding or shaking your head, because then the record doesn't come out clear about what your answer may have been. In addition, please wait for anyone questioning you to complete their question before you speak, so two people aren't talking at the same time, which is difficult for the court reporter. Importantly here, if any answer to any question that's raised would be embarrassing for you to answer publicly, let us know, and we will have an opportunity to discuss those matters with you individually in a more private setting outside the presence of your fellow jurors. Also, in this case, there has been a lot of pretrial publicity and media attention, and there will be a section of the case where we'll be discussing that, but for those of you who have been exposed to some of that publicity or have some knowledge about this case through that, please don't discuss any details during your questioning here in front of the other jurors, so that those jurors who do not have that information don't hear it from you for the first time. We'll take those up individually with each of you when we're further into the process here and allow you an opportunity to explain that more fully. At this time also, I'll instruct the attorneys to please avoid repeating any questions the court's already asked, but the attorneys do have the right to direct any follow-up questions to a juror regarding that juror's response to any previous questions of the court during voir dire. I'll next talk about the nature and purpose of juror challenges. The jury should be aware that during and following this voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, by which I mean each side can ask a juror be excused for some specific reason. In addition, the sides will have a number of what are called peremptory challenges, and those are challenges that each side can exercise without giving any reason for the dismissal. If you are excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned, because it has not. At this time, then, the court will commence with its voir dire examination, after which the attorneys for both parties will be given an opportunity to make their own inquiries. The first question I will ask then, as it relates to your questionnaires you completed when you came here last week. I'll ask you as a group, are the answers contained in your questionnaire still true and accurate to the best of your knowledge at this time? Yes. Okay, thank you. Let me ask a question now as it relates to the time commitment that will be required if you are serving as a juror in this case. If you are required to serve as a juror here, it will be for a period of time that the attorneys have estimated to be 8 weeks. And the question is whether or not that service for that time would create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case. So if anyone has a response on that time commitment and a concern they believe would create a hardship, would you please raise your red card? Okay, we've got 3 jurors, 1571, sorry, 1266, and 1569. All right, thank you for that. I'll review your questionnaires briefly and then take up those questions with you individually, also potentially allowing the attorneys to respond on that issue. So let's start with juror number 1266. If you'd raise your card again, please. All right, thank you. I note in your questionnaire, juror 1266, you didn't check or explain a hardship there. Is there something that you'd like to advise the court of at this time on that issue?
I'm the sole breadwinner in our home, and I'm taking care of my wife. She's ill, and my mother-in-law lives with us, and I take care of both of them. And if I'm out for 2 months, there ain't going to be any money coming into that household, and I'm going to have a lot of bills piled up by the end of that.
All right, let me take a quick look at your, you still have the occupation of a supervisor of a shop?
Yes, sir.
And if you are not there working, you don't get paid, is that accurate?
Yes, right.
Okay. Did you discuss at all with your employer the possibility that you may be required to serve here?
Yes.
Did they indicate they could make any kind of accommodation for you?
They were thinking about it. They say that for this week here, they're going to give me some time, but if I go on longer than that, I'll probably have to take all my vacation and then whatever else I got.
Okay. And could you explain a little bit more about the other part of the hardship beyond the financial side of who you're taking care of?
My wife.
Okay. All right, I'll allow for some follow-up voir dire on that specific reference for both the state and the defense as to juror 1266 on their request for excusal for hardship. Does the state have any questions?
Your Honor, the state has no objection to excusing juror 1266 for hardship.
All right, would the defense like to ask any questions?
Your Honor, the defense has no objection to excusing juror 1266.
Okay. Based on those responses as well as this court's review of your responses today in your questionnaire, I'll allow you to be excused, finding that it would constitute an undue hardship for you to have to serve in this case, given the length of the trial. I'll let you know something before you go, and if any other jurors are excused for any reason, please keep this in mind also. So that will complete your service as a juror in this case, and we appreciate your time coming in, filling out the questionnaire, and being here today. If you decide to discuss this case with anyone, be careful to respect the privacy and feelings of your fellow jurors, and please limit your comments to your own perceptions and feelings. If someone persists in discussing this case over your objection or becomes critical of your service for any reason, please report that to the court, and we may follow up on that issue. So I appreciate your time coming in today, and you can be excused. Next juror I'll discuss the hardship issue with is juror 1569. All right. All right, in this questionnaire also I didn't see any explanation as it related to hardship. So juror number 1569, would you indicate to the court why you believe it would be a hardship for you to serve in this case?
I just received word this morning from my human resource department that they would only allow 30 days. And anything beyond that, I would not receive compensation.
Okay, if this trial were to go for roughly twice that length of time for 8 weeks, do you believe it would pose a financial hardship that would be an undue burden for you?
I do.
All right, thank you for that follow-up information you received from your employer. Let me ask the state if the state has any questions and wants any follow-up or dire with this juror.
Your Honor, based on that information, the state has no objection to excusing this juror for cause.
Thank you, Mr. Wood. Mr. Archibald, do you have any voir dire for the juror?
We do not object to juror 1569 being excused.
All right, the court's reviewed that response as well. I do find that based on your response given today that serving for the entire period of this trial would constitute an undue hardship for you. So for that reason, you could be excused. Thank you for your service, and the same admonishment I gave the other juror about who you discussed the case with or reporting to the court any unwanted contact will apply as well. So you can be excused, and thank you for coming. All right, finally, juror number 1571. All right, juror number 1571, I've reviewed your questionnaire. You didn't expressly indicate a reason why it would be a hardship then. Would you describe to the court why you feel it would be a hardship if you had to serve in this case?
I'm just in a difficult situation. I'm unemployed right now. I'm trying to find work. I didn't state it because I'm not quite sure. I'm having a hard time getting interviews and things like that, and so as far as the time frame, I don't have any resources at this particular point in time. So I could, I guess, technically serve, but it will prevent me from finding anything. So that's why I didn't state it. I'm not quite sure because I'm in this difficult spot. I just don't have any resources coming in.
All right, I'd ask the state if there's any follow-up voir dire for juror 1571.
No, Your Honor, based on the representations of this juror today and in the questionnaire, the state has no objection to excusing this juror for hardship.
All right, Mr. Archibald for the defense.
Your Honor, we do not object to juror 1571 being excused.
Very well. The court's reviewed the questionnaire as well as the responses provided by this juror, I do find that it would constitute an undue hardship for this particular juror to serve at this time, given the length of the trial and his unknown employment situation and efforts to find employment. For those reasons, then, Juror 1571, with the thanks of the court, you may also be excused in this case with the same admonishment given to those previous jurors about contacts once you leave. Do you have any questions about that?
No, sir.
Okay, thank you so much for appearing today. Then you can be dismissed, and we will move on to further questioning. All right, it's my understanding those were the responses as it related to any difficulty with the time commitment. Was there any other juror that had any issue to raise on that matter? All right, I'll next just briefly make an overview regarding the knowledge of the case. We'll come back to that topic, as I mentioned, individually for each of you. However, in order to get the list of who we're going to talk to about that, let me just ask here of this jury pool, who here both indicated on their questionnaire and would say today that you have had no prior knowledge of this case through any of the media reporting in the case? All right, so jurors 1238 and 1370. Thank you for that. We'll discuss the issue of that later individually with the rest, also 1758. And 1210. Okay. We'll also review your questionnaires, and if either of the parties have any follow-up questions, those can be brought up as well. Let me next move on to the issue of the subject matter of this case. I explained already the nature of the charges in this case, but reiterating that the charges here involve charges of murder, conspiracy, and theft. Is there anything about the nature of those charges in this case that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? All right, no one answered affirmatively to that. I'll ask some further questions here, which you'll probably think should be obvious by what you said in your questionnaire, but I need to ask those to cover legal challenges pursuant to Idaho law. In regards to any relation to or acquaintance with the defendant, are any of you related by blood or marriage to the defendant, or do you know her from any business or social relationship? Okay, no one responded to that question. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you or any of the attorneys in this case? Are any of you, and I'll note on the record there was no response to that question, are any of you a party in any civil action against the defendant in this case? There was no response to that question. Have any of you ever brought a criminal complaint against the defendant, or have you ever been accused of a crime, of a crime by any of the prosecutors in this case, including Ms. Blake or Mr. Wood? Okay, there was no response to that. I'll next discuss whether there's any representation or relation by the attorneys. The question is whether any of you have an attorney-client relationship with any of the attorneys or with their law firms. So in order to fully answer that question, at this time I'll ask the prosecutors to introduce themselves again and indicate who they work with in their office, and then I'll ask the same of the defense. So starting with Ms. Blake, who's in your office, and then we'll move on to Mr. Wood. Or
Your Honor, if it's all right, I'll just answer for both of our offices.
yes.
Rob Wood, Madison County Prosecutor, and in that office, we have Mackenzie Cole, Spencer Rammel, Adam Garvin, Troy Evans, and as stated by the court, we've deputized Rachel Smith to help with this case. In the Fremont County Prosecutor's Office, there is Lindsay Blake, Tanya Rawlings, Rocky Wixom, and Blake Hall.
All right, thank you, Mr. Wood. For the defense, Mr. Archibald.
I'm a sole proprietor.
All right, and Mr. Thomas, who do you work with in your office?
There is Jordan Crane, Jason Gustavus, Timothy French, Alex Sosa, Tyler Salveson, Brad Rigby, Paul Butikofer, and Justin Bowles.
Thank you. Now that the council have indicated who all they work with, let me ask the question again. Do any of you as jurors have any attorney-client relationship with any of the attorneys here or anyone mentioned that they work with? All right, there was no answer to that question from any juror. Are any of you jurors related by blood or marriage to any of the lawyers in this case, or do any of you know any of the lawyers from some prior professional, business, or social relationship? Okay, no one answered affirmatively to that. Let me next ask a question relating to whether you have prior jury experience. If you've previously sat on a jury that went through a trial, would you please raise your red card? Okay, 1133. Has anyone else previously served on a jury? Okay. Juror number 1133, would you just explain when the case occurred, where it was, and if you recall what the outcome was? Was it a criminal or civil case?
Yeah, it was a civil case, and I think it was approximately about 20 years ago, and it was like a car accident type of case, and it was a non-guilty verdict.
Okay, and do you recall where that was that you served?
It was in El Dorado Hills, California.
Okay. Is there anything about your prior service on that jury that you think would affect your ability to sit as an impartial juror in this case now?
No.
Okay, thank you for your response there. I'll next ask a general opinion to the jurors, but a obviously important question. Have any of you ever formed or expressed an unqualified opinion that the defendant, Mrs. Vallow Daybell, is guilty or not guilty of the offense charged? There was no response to that question. Do any of you have any bias or prejudice either for or against the defendant in this case? Okay, no one answered affirmatively there. When you completed your questionnaires, there was a list of potential witnesses in this case. Those can be reviewed by counsel within the questionnaire, but I'll just ask you as a group, are the answers you provided in that questionnaire still accurate to the best of your knowledge as it relates to any witnesses you may know? Okay, thank you. Is there anyone here in this jury pool who would be unwilling to follow my instructions to you, the jury, as to the law that you must apply in determining this case? Okay, no one answered that question. Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict in this case? All right, no one answered yes to that. Are there any of you that, if selected as a juror in this case, would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? Okay, no one had an affirmative response to that question. And then finally, do any of you have any other reason why you believe you cannot give this case your undivided attention and render a fair and impartial verdict? Okay, no one responded to that question either. At this time then, the court will pass its voir dire to counsel for their voir dire in the case, beginning with the state.
Thank you, ladies and gentlemen. Again, my name is Rob Wood. I represent the people of Idaho in Madison County. Just really briefly, if any of you thought it was strange that there's two county prosecutors here, as you may or may not have noted when the court read the indictment the other day and then summarized it again today, there are allegations that crimes were committed both in Fremont and Madison County. So that's why there's two county prosecutors here. Before I get into any questions, just wanted to reiterate, if you do have anything you feel like you need to tell us, but you think it might be embarrassing or it's just really personal, please just let us know, and we can do it individually. We want everyone to feel like they can answer everything honestly and totally. And so, speaking of that, I want to talk to you about the phrase brutal honesty. Juror 1276. If I ask you, you're all right. If I ask you, what does brutal honesty mean? What is your response?
Giving the truth regardless of what the result will be.
Okay. What about juror 1210? What does that mean to you, brutal honesty?
Given the truth without regard to someone else's feelings.
Okay. Thank you. And the reason I'm asking that, there's a defendant here today who's been charged with very serious crimes, and she is absolutely entitled to a fair and impartial jury and a fair and impartial trial. And we have to rely on what you tell us to make sure that happens. Not only is she entitled to a fair and impartial trial, the people of the state of Idaho are also entitled to a fair and impartial trial. And so it's too important to the defendant, it's too important to the people of Idaho to not have honest answers. And I would add, to me, part of that is complete answers. So please make sure that you give us a complete answer. Just a real brief analogy. Who here has flown on a plane? I think everyone raised their hand. We all know how it goes. You get on the plane, you stow your luggage, and the pilot tells you, we're going to land at such and such place at such and such time. How many of you would feel comfortable if a pilot said, I might be able to land this plane? Nobody would feel comfortable, right? Because he's not getting you where he's supposed to get you. He's not doing what he needs to do. So, ladies and gentlemen, today you're the pilot. And when you're answering the questions, we need you to land the plane. And what I mean by that is that you give us those true and unvarnished answers. The judge spoke just very briefly about will you follow the law as it's given to you? Who here can think of a law or a rule at work or some regulation they don't particularly care for? By raise of hands. Almost everybody. Almost everyone can think of a law or rule they don't care for. And that's fine, because we all have different opinions. And we all think different things are fair. But what one person thinks is fair is different than what another person thinks is fair. And so for the defendant and for the people of Idaho to have a fair trial, there has to be an objective rule of law. and we all have to agree to abide by that law. And so when the judge gives you the instructions, it's possible you may not like the law. Can everybody here commit that whether you agree with the law or not, that you will follow the law as given to you by the judge or by the court in this trial? Can you raise your hands and commit to that? Thank you. And that might come up a little more later, but the judge spoke about pretrial publicity. Juror 1323. Do you believe everything you see on the internet?
Do I what?
Believe everything you see or read on the internet?
Absolutely not.
Absolutely not. Why not?
Because not everything out there is true. Some people put out fake stuff, true stuff. So, no, I don't always believe what I see.
Okay.
I do my own research into it if I'm wondering if, whatever I see, and then form my own opinion.
Okay. Is there anybody here who disagrees with Juror 1323? Juror 1273.
Yes.
Do you believe everything you see on TV?
No.
You sound pretty emphatic.
Yes.
Why is that?
Because television is meant for entertainment. It's meant to sensationalize. It's meant to keep you engrossed and coming back, and things like that require something that captivates the audience. Okay. And so it's not always going to be true. It's going to be something that's going to hook you and make you want to come back.
Okay. Does anybody disagree with Juror 1273? No? I'm not seeing anybody raise their hand. Okay. And so, as the judge has said, and as we will talk about later, there has been a fair amount of pretrial publicity about this case. Can everyone here commit that you will put aside everything you've learned from the media or outside sources and only make a decision in this case based on information received in this court? I raise a hand. Can everybody commit to doing that? Okay. I'm going to briefly speak, and the judge mentioned this, the nature of the case. The defendant in this case is charged with the murder of 3 individuals and conspiracy to commit murder. 2 of those individuals are minor children. In your questionnaire, you were asked if it would bother you to see autopsy photos. And so some of the evidence in this case will be, I'm going to use the words emotionally charged, and difficult to look at. Juror 1106. Just me telling you that, how do you feel about that?
I have seen a dead body before, so that's how I feel. I knew how I reacted to that, which was fine, and I had to deal with what I needed to take care of with it. I went to somebody's house. I thought they were having a problem, and somebody had died, and so I had to. You want me to tell the whole story?
Well, just briefly.
Briefly. So it was refugees that I work with. They didn't speak English. I didn't speak their language. The coroner was there, and they wanted somebody to get those people off the body because they needed to take it. That was me. So that was probably, one experience that I've had was walking in and not expecting it and seeing a body.
So you've had some experience then with something similar to that.
Yes.
So we need the jurors on this case, both the defendant and the people of Idaho need the jurors on this case to act with common sense and reason. So Juror 1106, if you see images or evidence that is emotionally charged, do you have any concerns that your response to that will overrun your reason and common sense in making a decision?
I have no reason to think that, no.
Okay. Is there anyone here who thinks that seeing that type of evidence, emotionally charged evidence, such as an autopsy photo, will overrun their reason and common sense in making a decision? This is where that brutal honesty comes in. I'm not seeing anybody raise their hand. Okay. Is there anyone here who will, let me ask it this way. Can everybody here commit that seeing that information, that you will still consider all the other evidence in the case and not make a decision just based on that emotionally charged evidence? Okay, everyone who feels like they can do that, can you raise your hand? Okay, and you can do that. Okay, thank you. I'm going to turn the time over to my colleague, Ms. Smith, and she's going to ask a few more questions. Thank you.
Good afternoon. I'm going to follow up briefly on some things, and we're going to talk about some of your questionnaires, okay? Let's just talk, let me turn quickly to Juror 1106. In looking at your questionnaire, there were some questions where I think you marked on there that you didn't understand some of the issues about beyond a reasonable doubt. Do I have that right?
That's correct.
Okay. Now, did you hear the court's instruction on that issue?
Yes.
Okay. Did that help clear it up?
No, to be honest with you, no.
Okay, fair enough. And it's hard, especially, I'm a visual learner, so if I don't see it. So let's talk about it a little bit. I also see, let me make sure I have my right juror, that you work in a pharmacy, correct? You're a pharmacy operations supervisor?
I'm not a supervisor. I work in health insurance and pharmacy in our pharmacy department.
Okay. Do you actually work where narcotics are stored, or are you more in an office?
No, I work from home. Not any longer. I have in the past, but no.
Okay.
I do not work around medicine.
Okay. Let's do this. Let's say that you were with a visiting relatives and there were some children present. Okay? And the children were told to stay away from the cookie jar in the kitchen. Okay? And every adult made it really clear, stay away from that cookie jar. And then you come into the kitchen and you see one of the very delightfully cute little kids standing there, and the cookie jar's open. There's crumbs on their hands, there's chocolate on their face, right? And it's, you look at them and you go, why did you eat that cookie? Right? Based on what you'd seen, would that firmly convince you that they had eaten that cookie?
No.
Okay. Why not?
Well, they just have crumbs. Maybe there were no cookies.
But there's chocolate on their face.
Maybe it was remnants in the bottom of the cookie jar.
Okay. Okay. And so if you saw those pieces sitting on their face and they wouldn't answer you when you said, hey, did you eat that cookie? They just wouldn't talk. Would that help you be firmly convinced?
No, unless I seen them eat the cookie, would I know?
Okay. So I think that it probably, that tells us a lot, because unless you see it or see an item, or unless I saw him do it, you couldn't make the decision that you couldn't be firmly convinced.
Correct.
Okay. Now let's extrapolate that to this situation. Are you going to be able to have people show you bits and pieces of things and reach a conclusion that leaves you firmly convinced that a crime occurred? Or do you have to see it?
I would say no, I do not have to see it, because I would look at a bunch of different evidence and have to make that decision from there. And if I wasn't 100% then I couldn't make that decision.
All right. If I wasn't 100%, you couldn't make that decision?
Yeah, if I wasn't 100% sure that that child ate that cookie, I can't say you ate that cookie.
Okay. Even if you received an instruction from the court saying, hey, if you're firmly convinced, even if it's not 100%, but you firmly convinced based on logic and reason, and the court says you don't have to prove it to 100%, you don't have to remove all doubt.
That's probably where my answer was. I was a little bit confused on that questionnaire with that one.
Yeah.
For exactly what you're saying.
Right. And that the reason it's on everything on that questionnaire is there for a reason, because there are people who are like, Your Honor, Ms. Smith, I understand what the court's telling me, but I need to be 100%. I need to be more than firmly convinced. I want to see it. And do you think you're in that position where you need to see it?
If I didn't see it happen, then I'd have to be convinced by other means. And that would be with the jurors, or, in deliberation, that sort of thing. I would have to know, I'll go back to the cookie thing. I'd have to, if it was that thing where I'd have to, hey, did anybody see this cookie? Or the kid eat the cookie? That sort of thing.
Okay. And so, without getting too far into the court's instruction, because we have to follow the instruction that's given us by the court, let me do it this way. A person who witnessed the child or anyone doing something, that person's a witness, right? Can a witness ever be a juror on a case that they're a witness on? Have you ever heard of that? No. I see lots of shakes of head no, so the person who's 100% because they saw it couldn't be a juror, could they?
I don't know law. I don't know.
Okay. Let me tell you, under the law, they can't. If you're a witness, you can't be on the jury. You can't see it, be a witness, and then also sit in judgment. Does that make sense?
That makes sense.
Right?
When you say it that way, yes.
Right. And so jurors are having to take evidence that is given to them and supplied in the courtroom, ruled admissible by the court, and consider that evidence, and then make a decision that leaves them firmly convinced. And so while a witness can be 100% certain of what happened, jurors have to be firmly convinced. Does that make sense?
Yes.
Okay.
Yes.
And only you know what's inside your head. Do you see the difference between those two things?
Yes, I do.
Okay. And only you will ever know, look, if I don't really see it, if I'm not 100%, I just don't think I could sit in judgment and consider convicting someone. Or can you extrapolate, and if you believe each part of the items given to you beyond a reasonable doubt, if you're firmly convinced, you could convict. So we need to know, do you need to be that sort of 100% all doubt removed? Or can you be in the category where you're firmly convinced?
Your Honor, firmly convinced is not the burden of proof in this case.
I do agree. I think we've discussed that term too many times, Ms. Smith, and it may confuse the jurors about the correct standard of proof in this case, which the court's instructed already with its instruction of what constitutes beyond a reasonable doubt. So I just request that you modify your line of questioning to comport with that.
Sure. Jurors have to believe and use their reason and common sense to believe that a crime has occurred. All right? Understanding that, do you still feel you're confused on beyond a reasonable doubt?
No, you've helped a lot.
Okay.
I understand.
Okay. So understanding that, does that sort of change some of your answers on your questionnaire?
No.
Okay. All right. Fair enough. Your Honor, I'd move for cause on juror number 1106.
On what basis?
On the basis that she can't follow the court's instructions.
Was that on responses made today on the record or responses within the questionnaire?
Both, Your Honor.
All right. Would you direct me where in the questionnaire you're referring to?
Let me pull up. It's loading, Your Honor. What page is it? Mine's just so slow to load.
Page 7.
Page 7, Your Honor. Look and see. Let me see.
Your Honor, it's page 7, lines 8 through 11.
All right. Would the defense like any response to the challenge for cause on this particular juror? Yes.
Judge, may I unmute the simulcast?
Thank you.
Good to go, Judge. Thank you.
All right, thanks. The court has before it a challenge on juror number 1106. I just had a brief sidebar with counsel. While the court would not find cause exists based on the responses as they relate to the standard of what is beyond a reasonable doubt as defined in the instruction the court previously read, upon further review with counsel, the court found other grounds based on potential bias as it related to some questionnaire responses involving some media exposure, and the court understands at this time that both sides feel it would be best to excuse this juror. Does the state agree that for those grounds juror 1106 can be excused?
Yes, Your Honor.
Does the defense agree as well, Mr. Archibald?
Yes, Your Honor.
Okay. Well, based on that and having reviewed further the questionnaire, again, not based on the responses to that line of questioning in particular, but for other reasons as indicated in the questionnaire, juror 1106, I'll allow you to be excused based on that challenge and sustain that with the stipulation of counsel. So you will be excused. As I indicated from that prior instruction, if you wish to discuss the case, please respect your fellow jurors' privacy and feelings if you do that, and if you if somebody is insisting on talking to you and you don't want to discuss the case with them, please report that to the court. With that, the court extends you sincere thanks for the time you've put in today and last week in this case, and your jury service is through for this case, and you're excused. Thank you.
Thank you.
All right, Ms. Smith, you can continue your voir dire of the panel.
Thank you. And one of the things that is so important to both sides, Ms. Vallow Daybell and the people of the state of Idaho deserve a fair trial. And because of that, we have to ask sensitive topics. And sometimes that just means this case is not for the person who's in that chair. Does everyone understand that? We're not intending to pry or be difficult, but both sides really have to do their due diligence and follow up. So if we do that, please don't be offended. Please know we're just doing our best to make sure that both sides get a fair trial. Is that okay with everybody? Okay. All right. Juror 1133. I see that there was some questions about reasonable doubt. I'm not going to rehash that. I think everybody had followed our conversation. But I want to ask you a couple other questions. Okay?
Okay.
All right. You understand that in a criminal case, when the people of the state of Idaho bring charges, the people, the prosecutors, have to prove that crime beyond a reasonable doubt. You understand that?
Yes.
That means only the prosecution has to do anything.
Yes.
Okay. Do you understand that every defendant brought before a court on charges from the state has a presumption of innocence?
Yes.
Okay. And with that presumption of innocence comes the state has the job to prove each part of the crime beyond a reasonable doubt.
Yes.
All right. Now, in your questionnaire, I want to make sure that that there's nothing about sort of the conversation we've had today that would be confusing to you in terms of whose job it is to prove the charges. Whose job is it to prove the charges?
Prosecution.
Okay. And what level, how do they have to prove it? To what standard?
Beyond a reasonable doubt.
Okay. And if the prosecutors fail to do that, what happens?
You're not guilty.
Okay. And so the judge is going to give you those instructions. You actually get to take them back with you when you go in for deliberations, and you get to read them. And so jurors can't add to that, and they can't take away from that.
Correct.
Okay. And so that means that a juror has to agree to follow the law and hold the state to beyond a reasonable doubt. Nothing more and nothing less.
Correct.
Okay. Do you have any concerns on that?
Not at all.
All right. You did serve on prior jury service, I see.
I did.
Okay. And forgive me, I didn't write it down. Was it civil or criminal?
A civil case, a traffic
Okay.
kind of accident type case.
Okay. So, and the court has asked you that. Were you the foreperson?
Excuse me?
Were you the person in charge who had to sign the piece of papers?
No.
Okay. All right. All right. Thank you.
You're welcome.
Okay. Juror 1210. Okay. The notes indicate, and again, if this is something we need to talk privately, we can, but your wife is an assistant prosecutor in Ada County? Or does she work at the Ada County prosecutor?
She's a receptionist for the public defender's office.
Oh, okay. Oh, okay. I must have misread.
I think I put one down wrong.
Okay.
It asked multiple times on there, and I think I wrote one of them down wrong.
Well, and that's why we do this. A lot of people will go, wait, why are you asking me about my questionnaire? For that exact reason, right? Is there anything about her work in that office or any stories she might have told you about the courthouse that you could be weighing on your mind or you'd be thinking about while you're evaluating the evidence on this case?
None.
Okay. And so you understand that the state bears the burden of proof?
Yes.
Okay. Now, that means when we make accusations of the charge of conspiracy, okay, that individuals are charged for conduct and working with others to achieve a certain end, right? Okay. And in that situation, the state has to prove all those parts that they charge on the conspiracy. Does that make sense?
Yes.
Okay. And that the person had to be a part of that conspiracy and contribute towards it. Does that make sense?
Understood.
Okay. And so when that happens, a person can be responsible for the entire outcome, even if they only did certain parts.
Yes.
Okay. So, for example, the driver in a bank robbery, the driver of the getaway car, is guilty of the bank robbery, even though they just drove the car. Does that make sense?
It does, yes.
Is there anything about that situation that would cause you concern?
No.
Okay. Does it make sense?
Yes.
Is there any of the other jurors who are like, look, I can't treat the driver of the car or the planner as the same as the person who robs the bank? Does anybody have concerns with that? Okay. I see shakes of heads. I know it's been a long day. I appreciate you hanging in there with us. All right. Juror 1273. Okay. Did I read the questionnaire correctly that you have triplets?
Yes.
Busy. Okay.
Yes.
All right. And how old are they? Forgive me, I didn't write that down.
They're 13
Okay.
boys.
You're busy. So having 13-year-olds, boys, one of the victims in this case was younger than that, but a boy, and then there's the victim, the girl is slightly older than that, okay? Having children in that age range, knowing that the victims, the people who died in this case, are in that age range, are you going to be able to make sure that you provide Ms. Vallow Daybell the presumption of innocence? I'm sorry?
Yes.
Okay. You understand that it's natural human reaction to dislike or feel sad about the death of children, correct?
Yes.
And as a mom, it's not unusual to feel that emotional overcharge when you see those issues, right?
Yes.
Okay. But can you assure us that your personal situation won't make you automatically convict someone?
Yes.
Okay. Is there anything about your home life or the fact that you have 13-year-olds, 3 boys, that's going to cause you to make it easier on the state? Say, you don't have to show me as much evidence.
No.
Okay. And I don't want to, we can circle back if we need to. Mr. Wood asked a bunch of questions about the pictures. What about your juror 1276? Did I read that correctly, that you have 3 kids but a 15-year-old?
Yes.
Okay. You heard my questions that I asked of juror 1273.
Yes.
Okay. Do you have any concerns with those questions? Would your answers be different than hers?
No.
Okay. All right. You can judge the facts and the evidence based on your reason and your common sense.
Yes.
And so, juror 1276, the judge is going to give you those instructions. He's going to define, and you're going to get to take back the instructions, definitions, back to the jury room. Okay? And when you get those definitions back there, it's going to tell you what has to be proven beyond a reasonable doubt. But it's not going to tell you how the state has to do it. It's not going to give you a formula that you have to have this type of evidence or this many witnesses. Do you understand that?
Yes.
Okay. And so I got to ask, is there anything about this situation where you're thinking in the back of your head, I'd kind of like to see this type of evidence?
No.
Okay. You understand that the state bears that burden, but the judge isn't going to say what we have to do, only that we have to accomplish it.
Yes.
That can mean, and I'm going to use the circumstantial evidence sort of example of the cookie crumbs example, if you walked in and you'd told your 15-year-old, don't touch the cookies, they're for dinner tonight or for afterwards, and the 15-year-old standing there, chocolate on his hands, chocolate on his mouth, crumbs down his shirt, nobody else is in the room, and the cookies are missing, right? Are you going to be firmly convinced that that 15-year-old ate the cookies, and are you going to ask him, why'd you eat my cookies?
I don't think I'll be firmly convinced.
Firmly convinced?
Yeah, I'm sorry.
Would your reason,
Yes.
would your reason and common sense lead you to conclude?
Oh, yes.
Okay.
Yes.
Let's do it that way. So your reason and your common sense would lead, and would you hold him accountable for it and have a consequence for disobeying you and eating the cookies when he shouldn't?
Yes.
Okay. And so that, even though you didn't see him eat the cookies, but the different pieces of evidence led you to conclude he'd eaten the cookies, right?
Yes.
And you're going to hold him responsible and give him a consequence.
Yes.
All right. And so that's what they call circumstantial evidence. And so you would be holding him accountable based on circumstantial evidence. Does that make sense?
Yes.
All right. Now let's take that and apply that to this situation. All right. Let's say the state, you get the instructions from the court, you go back to the jury room, and the court has given you the definitions. And the state is giving you circumstantial evidence that proves to you beyond a reasonable doubt each one of the parts of the definition the court gave to you. Can you consider convicting somebody using your reason and common sense to convict somebody when the state has given you only circumstantial evidence?
Yes.
Okay. Hard, but you could do it.
Mm-hmm.
Especially if you received an instruction from the court saying you have to use your reason and common sense to walk away. I appreciate you thinking about it, and that's exactly what we need. Any hesitation on that?
No.
Okay. Now, everybody has probably heard my conversation with juror 1276. Is there anybody here who's like, Ms. Smith, I heard that, and I understand what you're saying, but I don't think I could consider convicting somebody, even if I was firmly convinced of each part, based on circumstantial evidence alone. Can everybody assure us you can consider that issue? And if you're firmly convinced, consider convicting someone based on circumstantial evidence? Okay, thank you. Another thing, let me see. I think I have a couple people. Juror 1370. Thank you, ma'am. Did I see that you have a nursing degree?
Yes, I do.
Okay. And in part of your nursing degree, did you take any work in like the pathology lab, or did they have you work in that? Or did you not go down that path?
No, that's not part of the nursing degree. It's more the interpretation of the results that come from that department.
Yeah. Have you ever had to be a part of that?
No.
All right. There's going to be evidence from some forensic pathologists. Okay. The MD, the MEs, the coroners, that sort of person. Have you ever had any contact with any of those people?
I mean, I've had like coroner cases where like we have to let the coroner's office know when they come and technically investigate the death, but outside of that, no.
Okay. And so you used a phrase, investigate the death.
Correct.
So you're aware of the concept of what coroners have to do, right?
Correct.
All right. And so coroners will investigate a death, and medical examiners will investigate the death based on what your experience is, right?
Correct.
And they kind of they try to decide how the person died and what type of death it is, right?
Correct.
All right. How they died, like what thing caused their heart to stop bleeding, pumping, and their brain to stop functioning, right?
Correct.
All right. And then the medical examiner and the coroner then talks about what type of death it is. Was it the death at somebody else's hands, right?
Yes.
Okay. So there are situations, can you consider situations where the medical examiner or the coroner might tell a jury to consider convicting somebody of murder, even if they can't exactly say the cause of death, what caused the person to die. They can tell it was a homicide in their opinions, but they can't tell what actually caused the heart to stop beating. Does that make sense? That situation could happen?
Yeah, it does.
Okay. And given sort of your nursing and some exposure to the concepts, do you think you could consider convicting somebody of murder if the state can't show you exactly how they died?
Yeah, it's really hard to actually prove everything every time because things change after people pass away.
Exactly. And so if the state could prove that someone died at the hands of another and all of the elements of the instruction, but couldn't exactly tell you exactly what caused their heart to stop beating, could you consider convicting somebody of homicide?
Yeah.
Okay. Is there anybody here who heard that? Thank you, ma'am. I appreciate it. Is there anybody here who heard that exchange with Juror 1370 and is like, Ms. Smith, that's pushing it. My personal beliefs wouldn't let me do that. Can everybody assure us they could consider that situation? Hold the state to its burden of proof? All right. Thank you. Okay. I'm just going to run through a couple quick things. Check with my colleagues, Judge, and then. One moment, please, Judge. Juror 1370, I just want to ask about your questionnaire. Did you, maybe I read it wrong, do you have a wedding coming up?
Yeah, it's on Sunday, the 16th of this month.
All right, well, congratulations.
Thank you.
Are you planning a honeymoon?
No.
Okay. Are you going to have to take some time off to get ready for it?
No, I actually already have that time off because it's the week before my wedding.
Okay.
So, like the week before and the week of.
Could you give me that date again? Was it April 16th?
Yep, Sunday, April 16th.
Okay. Having jury duty the Friday before your wedding or during, right before your wedding, is that going to cause you any concerns?
I don't think so.
Okay.
I mean, I'm not leaving town. I'm not doing anything. Like, I have nothing planned that week.
Okay.
The week before.
Okay. So is there anything about the fact that the state would and the courts would be asking you to be here at jury duty the week before your wedding that's going to cause you problems?
I don't think so. I thought about it pretty thoroughly when I filled out my questionnaire.
Okay. Anything about that you might hold against Ms. Vallow Daybell?
No, she didn't have anything to do with that.
Okay. All right.
My number got called.
All right. Thank you. Okay. Thank you, ma'am. I appreciate it. Thank you, Judge.
Okay, that'll conclude the state's voir dire of the panel. We'll pass on now for the defense to exercise their voir dire. Mr. Archibald, you can inquire.
So, Juror 1370, talking about this marriage, do you want some time off for like a honeymoon?
I'm not planning one. We moved everything up because my grandparents' health kind of went downhill hard and fast. So.
Okay.
Yeah, we don't have anything planned.
Because I could challenge you for a hardship if you want to get out of it. If you want to spend some time on a honeymoon.
No, I'm doing nothing. We got nothing planned.
Okay. All right. Thanks.
Yeah.
A lot of my questions have already been asked, and we've been at this a while, and you've been at you've been here at the courthouse a while too, so I'll be brief. By a show of hands, how many have been exposed to the media, the publicity about this case? And we'll want to talk to you individually because we don't want you to talk about it with those who haven't heard about the case. So we'll talk to you individually about that to see if that's caused you to form an opinion that might influence your decision. Juror number 1133, I see that you're retired Department of Corrections. And what did you do at the
Correct.
What did you do at the Department of Corrections?
I was a correctional officer for 28 years.
Out on the desert there between Boise and Cuna?
No, I was in California. I worked 16 years at the California Medical Facility in Vacaville, and then I worked 12 years at Old Folsom.
Okay. And then you retired and came to Idaho?
I did, correct, 10 years ago.
Okay.
Yeah.
Anything about your experience as a correctional officer that would cause you to be concerned about your ability to be fair and impartial?
Not at all. I would never want to send anybody to prison that didn't deserve it. Working in there, I would have no problem like that.
Okay. All right. Thank you. And juror 1210, I think you mentioned that your wife is a receptionist at Public Defender's Office.
That's correct.
Yeah. Did she talk about her job much, or?
Not much at all. I know she answers the phones from sometimes inmates and sometimes people that are out on probation. It's about the extent of what I know she does.
Anything about that experience that would cause you concern about your ability to be fair and impartial here?
None whatsoever.
Okay. Thank you. Juror number 1238. You indicated you're retired. Retired at what?
I was carpenter. I was a carpenter. I'm sorry.
Okay. And you had one comment in your jury questionnaire that said, "I don't know if I can be fair." Do you remember writing that down last week?
I don't recall it specifically.
Do you know what you were meaning? Was it that I haven't heard the evidence, I don't know if I can be fair, I don't know what kind of case it is?
It's just that I don't know if I can be sure that I make a proper decision every time.
And what's that based on?
Life experience.
Okay. Sometimes you've made some decisions that you found out later are wrong?
You're right.
And sometimes you've made decisions and you found out you were right?
Sometimes.
And so and that makes sense. Your comments make sense about what you were meaning, that I want to be fair, but I don't know if I can be.
Given proper time and deliberation, I think it wouldn't be a hard thing to be sure at the end that I was making the right decision.
Can my client be assured, if you are one of her judges, that you will be fair to her?
Yes.
Okay. All right. Thank you. Your Honor, the rest of my questions go to the pretrial publicity. If we could take them up one at a time.
Very well. Thank you, Mr. Archibald. All right, at this time, we'll determine who we will have brought back in individually for more voir dire. I asked the question earlier, but I think I've seen a little bit of equivocation maybe. I want to confirm again before we do that who would indicate that they believe has not had any exposure to media in this case before they were called as jurors. I'll kind of go in a different order here. Starting on the back row, juror number 1758, is that correct? Okay, and on her, then do the parties pass that individual for the individual voir dire section?
Yes.
In other words, I'm asking if it's okay that they not be returned for individual voir dire.
Yeah. Yeah.
About the case.
I think we would like to ask a few questions on individual voir dire, Your Honor.
Okay, and that may have been one where this is where my list may have gotten turned around a little bit. So let me just have again the list of people who indicated they had not had any prior media exposure. If you'd hold your cards up. Okay, we do have 1758. We'll have you return for some individual voir dire. On the back row, 1370. Do the parties agree that that juror would not require any individual voir dire?
Yes.
Yes.
Okay. Moving on to the front row then, we had somebody also that stated that was juror 1238. Do the parties agree would not need to return as well?
Yes.
Your Honor, the state would like to question 1238
Okay.
individually.
We'll have them brought back in, and then juror 1210, I think, kind of vacillated back and forth on whether there's any media that you're aware of or not. Is that correct? Were you unsure about whether or not you had any prior media exposure? I think you indicated you had not, and then it looked like maybe you were thinking maybe you did know something about the case.
Something that came up last week.
Okay, we'll discuss that with you individually as well then. So I think then that will be everybody returning except for juror 1370. Okay, so we'll take a brief recess now just to let the jurors recess to the jury room, and why don't we start off and I'll get that list confirmed and we'll have the lowest number juror that's coming back for additional questioning. I think that'll be juror 1133. You can remain seated if you're okay to go on for a moment longer before you get a break. Okay, we'll start there. All rise for the jury. All right, at this point, I believe we stopped the simulcast proceeding of this. In addition to any matters relating not just to media, but any other sensitive issues that may have come up with the questionnaires, I'd ask council to take those up. So we'll start with our juror 1133 that's still here. On that questionnaire, there was a reference of some viewing of TV news. Let me just inquire, before I reviewed with you in court both last week and today what the charges are, did you have any knowledge or know what this defendant had been charged with?
The first time I heard about this case was when she was arrested. I heard on the news in Hawaii, and that was, I don't know, I think 2 years ago maybe now.
Okay. Do you recall any other details about what she may have been charged with anywhere, including here?
Yeah, I think it was for the murder of the children or something like that.
Okay. Did you view anything outside of news coverage? Did you go look up any stories? Did you watch any documentaries or made-for-TV movies or dramatizations or anything like that?
Not at all.
Okay, that concludes the court's questioning on that issue. If the state has any questions, please inquire at this time.
The state doesn't have any questions, Your Honor.
All right, Mr. Archibald for the defense, any questions for this juror?
No, Your Honor.
Okay. Do either side have a for-cause challenge at this time for the juror?
No.
No, Your Honor.
Okay, thank you for answering those questions, Juror 1133.
You're welcome.
We'll have you return to the room there with the bailiff, and we'll give you further instructions shortly. Let's next have, if I'm tracking right, it'll be Juror 1210, I think we're bringing in. If you could, use the microphone as well for the record there.
Is this on simulcast?
No.
Oh, okay, sorry. We worry that there's some inconsistency in his responses, trying to get to the page. He would appear to have multiple convictions. Let me pull it out. Domestic assault, domestic violence, this juror 1210. In Arizona, domestic, at least 3 for domestic violence, Your Honor, and we're not sure that's consistent with his responses on his jury questionnaire. We certainly could question him about it. We will handle it however you want us to.
Okay. On that questionnaire of Juror 1210, then we're looking at page 8, lines 27, 28. There is a disclosure there. What's the defense position on those disclosures? I guess what I'm hearing is the state, it sounds like, has done some additional investigation and feels like maybe that wasn't a complete disclosure. Is that correct?
Yes, Your Honor.
All right. Mr. Archibald or Mr. Thomas, do you wish to further question this juror on those issues?
When I read it, I didn't think the convictions were his. I thought it was a family member. But I could have been wrong.
Yeah, the question, as I read it, doesn't really make them specify because it just reads, have you or a family member? And he typed yes, so probably could ask a more specific question, but I'm hearing from the state, it sounds like that this individual juror probably was who they reference in their questionnaire, correct?
Yes, Judge, and we have his picture. It's the same person. And there's more than one, so it's not just isolated. He went to 10. There's one,
If
two,
they pulled up the
three.
if they pulled up the NCIC on him, I'll take their word for it. I will not object to their request for challenge.
Okay. Well, the question then is, it's not a disqualifying conviction by law that I understand for cause.
Yes, it's not disqualifying for cause. I think the state's concern is the failure to be forthright and as evidence of an inability to follow the court's instruction or an unwillingness to follow the court's instructions.
Okay, fair enough. I think those are grounds so that I can consider. So with that clarifying grounds for consideration, the state makes a challenge. Is that correct?
Yes, Your Honor.
Does the defense join in the challenge?
Yes.
Okay. The court has considered the responses and the information received now as to juror 1210 and finding that the responses in the questionnaire perhaps weren't as forthright as they should have been without objection from either side. With that challenge raised, I will find that they'll be excused for cause for that issue and potential bias in the case. So juror 1210 will be advised that they are going to be excused based on the challenge. So the next juror we'll bring in then, I think, will be 1238.
Your Honor, on that one, it's a similar situation, but this juror in his questionnaire line, page 8, line 27, did say they were jailed a few times for misdemeanor offenses. And so it would appear he has misdemeanor convictions and misdemeanor probation violations, and that he was sentenced for at least a 90-day for driving while licensed, driving under the influence, and for another leaving the scene of an accident. So the question is, if the court is satisfied, because he did put in there, I'm just raising it because I worry that it's inconsistent and I don't want to mention one and not mention the other.
I understand that. That time when I read that, I think that it's accurately stated. Maybe they didn't want to further explain. If they're not disqualifying reasons, then they shouldn't be excused just because of misdemeanor convictions. However, I'll ask from the defense while we're bringing this potential juror up if there are other issues you think ought to be raised and whether we ought to bring 1238 in for additional questioning as it relates to those offenses, or do you want to put anything on the record on this juror?
Juror 1238 was the juror who didn't know if he could be fair, so I'm okay excusing him.
Okay. Based on then a challenge that I think was previously brought up also on the record with the questionnaire by the defense, as well as do I understand the state is making a for-cause challenge at this point on this juror?
Yes, given the ambiguity in his answers, Your Honor.
Okay. The court finds then that there are grounds to allow for the dismissal of this juror for those concerns raised by both counsel, and without objection, juror 1238 will be also excused for cause, and I'll advise that juror of the same once they return. So that will take us up next to juror number 1273 would be the next we'd bring in. Is that correct?
That's what the state shows, Your Honor.
Okay. If there's no issues there, take up out of their presence, let's have juror 1273 please brought into the courtroom for their individual voir dire. All right, welcome back at your 1273. We are conducting individual voir dire to review the information through your questionnaire, where you've indicated that you've got quite a bit of knowledge about this case from prior exposure to media or publicity in the case. To be clear, there's nothing wrong with that or having followed the case. People are curious and can read whatever they want on the news. We're just determining whether or not that may impact your ability to be fair and impartial in this case and allow for some more detailed questioning on that issue. So in your questionnaire, you do have quite a few responses where you've referenced things you've learned about the case. Let me ask you a couple of specific questions, and then I'll let the attorneys ask you as well. Before you came into court for your questionnaire last week, as well as today, did you know what this defendant had been charged with here or anywhere else?
I didn't know like all of the counts. I only knew that it was related to her children were missing. I didn't follow the story at all. I just happened to learn about it. And I don't even know when I learned about it. I didn't even know what year it was. But I had gotten some news about missing children, and as a parent, it, that caught my attention, but I didn't actually follow the story.
Okay. Did you seek out any information specifically to follow the story? I know you somewhat just answered that, and let me ask you a few more questions on the point. Did you follow any, did you view any documentaries or movies about the case, or 48 hours specials, 2020, any kind of news things that focused on this case?
No, I don't have like regular television.
Okay. It's pretty common these days.
Yeah. I don't watch Fox News. I don't watch CNN. I don't watch any of that.
All right. That concludes the questions I had as it related to this juror with the pretrial publicity. Let me have the state ask if they have any questions on individual voir dire for this juror.
The state does, Your Honor.
Okay.
Do you have Netflix?
Nope.
Okay. So just looking at some of your questions, it sounds like you haven't followed the story, but you've seen some of the articles, right?
I remember one article, and that had to do with Hawaii.
Okay.
And it caught my attention because I got married and honeymooned in Hawaii, so that's why it caught my attention.
I was just looking at your questionnaire, though. It talked about you read Lori was transferred to Ada County.
So the week of, I don't even know what week it was, right before I got called for jury duty, I had saw her name on Google, like it came up under Google News, and it said that she was transferred to Ada County. And it only caught my attention because I knew I had jury duty the following week. So it made me think, I wonder if this is related, if that may be one of the cases.
And did you look at did you watch the video that was accompanying it? Because I was looking at your questionnaire.
I didn't see a video. I saw like just a publication, just her picture that said she was transferred to Ada County.
Okay.
That's all I saw.
Okay. I'm just kind of scanning to make sure I understand. I don't want to misunderstand. Now, and just looking at the questionnaire, did you talk to a friend about the case right before you started jury duty?
I told a friend I had jury duty service.
Okay.
I didn't talk about the case because I didn't know what I was being called for.
Gotcha.
Yeah.
And it's hard to understand. So,
Sure.
In an abundance of caution, Your Honor, I think the state is going to move to request that the juror be removed for cause.
Okay. Let me get any input from the defense on the challenge from the state.
Your Honor, we would agree with the the challenge because she has watched an internet video of the case, even though doesn't remember exactly what you want, it could be prejudicial. So we'll join in that.
All right, thank you, Mr. Archibald. Well, juror 1273, again, we're trying to just assemble a pool of jurors here that has the least amount of information about the case. Again, absolutely nothing wrong with reading about it, following the news. Probably not, in this case, qualifies you to be the best juror to sit on this case. So the court appreciates your time in filling out the questionnaire, coming in today, being honest in your answers. Thank you very much. You're excused with the thanks of this court. Based on the challenge, I'll find this juror is to be excused. And as I mentioned to the other jurors that were excused as well, please respect your fellow jurors' privacy and feelings if you decide to discuss this case with anyone else. And if somebody wants to talk to you about this case and you don't want to talk to them, please advise the court and we'll take that up. All right, thank you so much for your service. Let's next bring in juror 1276. All right, welcome back, juror 1276. We've got some individual questions for you based on responses that are contained in the questionnaire you completed for the case, relating to some knowledge you may have of this case, so we can discuss those matters in more detail here outside the presence of other jurors. In this case, let me just ask a couple of questions of my own before the attorneys ask you questions. Before you came into court and were advised of the charges that I read, both today and last week when you got your questionnaire, were you aware of what this defendant was charged with here or anywhere else?
No.
Okay. When you have discussed how you've seen or heard about the case, you talked about a Dateline broadcast. Was that something you watched that came up on TV?
Yeah, it came on TV, and as I indicated in my response, I was working on my computer at the time, which is kind of usually I'm a little something will pick up and I'll listen for a second and then go back out, so it didn't have my full attention.
Okay. Have you watched any other documentaries, news specials, dramatized movies, anything like that involving this case as the subject?
No.
Okay, thank you for your responses. That concludes the court's questions. I'll pass to the state if you have any individual voir dire.
Thank you, Judge. Ma'am, I'm just kind of looking at a couple of things. It mentioned that you saw information that she lived in Idaho Falls, but had previously lived in Arizona.
Mm-hmm.
What did you heard about, long day, I'm sorry. What had you heard about Arizona?
I think that was just one of those things that came up on that Dateline thing where Arizona was mentioned.
Okay.
I just knew that was part of the situation, I guess.
Okay, what part do you think it, if you remember?
I don't recall.
Okay. Had you seen Netflix on this?
I don't recall what it was streamed on. I mean, it was probably streamed because that's what we do.
Okay. So do you think it was a Netflix special or was it a Dateline?
I want to say, gosh, I really can't answer that. I don't have a certain. If I had to guess, I would say just a Dateline.
Okay. Let me just go back and look. How long ago was it? About approximately.
I want to say at least 2 years.
Have you talked about it? I see. What did I read that right? That your mother's an attorney, retired attorney?
Yes, family law.
Okay. You talked to her about it at all?
About her job?
About this situation?
Oh, no.
Okay. Anything about your? I also see you have an ex-sister-in-law that's a sheriff.
Well, yeah, it was. She's not. She works for the Orange County Sheriff's Association, so she does benefits.
Oh, gotcha. Okay, so she's not a deputy.
No.
Oh, okay. All right. All right. One moment. Thank you, ma'am. One moment, please. Just following up on a part of your, and it could be just looking at the questionnaire. There was an answer on your questionnaire that, where you had to write the numbers 1, 2, 5. The statement was, I would review all the evidence before I made a decision in this case. And you put it sort of as, I think it was the opposite. You put it as dislike.
Okay. Then I probably did not mean to do that. And I noticed I did that. I try to go back and read because sometimes I'll get going and not pay it, or I'll transpose things. So I know I caught one on another question where I did that. So I would say that is the opposite.
Okay. And the reason we're kind of asking is I just want to put it in context of having watched whatever it was you watched versus that's what I'm looking at is there any shot that some of the stuff you watched would make you not consider the evidence in the courtroom?
Oh, okay. Yeah. No, I would want consideration of what is presented here.
Okay. All right. Thank you.
All right. Questions from the state for this juror? I'm sorry, from the defense for this juror, Mr. Archibald?
On this Dateline special, do you remember the name Melanie Gibb?
No.
Do you remember them interviewing Lori's friends during the Dateline special?
No.
What do you remember about Dateline?
I remember one scene in a car driving or something, like trying to get an interview. And I think that's pretty much. And then there was one other one where it had to do with Hawaii and trying to get an interview.
Like a reporter.
Yes.
Chasing down Lori,
yes.
Trying to talk to her.
Mm-hmm.
Thank you, ma'am. Your Honor, the Dateline special and the Netflix special were pretty similar in rebroadcasting those news reporters, and so I think it'd be difficult for jurors to unsee that. So just to be on the safe side, I'm going to challenge juror number 1276 for bias.
All right, Mr. Archibald, does the state have a response to the challenge?
Judge, we're not going to oppose it simply because we don't know whether it was Dateline or Netflix. I think, we may not join, but we're not going to oppose it.
Okay. I've reviewed the questionnaire as well for juror 1276. First of all, very much appreciate your comments in there and your candor. This is the reason we go through this process, to try to make sure that a trial can be as fair as possible. Some of the detail that is listed just from even brief exposure is concerning for the court as well, that potentially could conflict with evidence presented at trial or the memory of this particular juror as it relates to what was seen at trial versus maybe what was seen through pretrial publicity. I find there is good cause to grant the challenge of the state for potential bias that could occur because of that. So Juror 1276, thank you so much for your time. You'll be excused based on that. As I mentioned to other jurors, you're free to talk about this case to others as long as you respect the privacy and feelings of your fellow jurors. And if anybody wants to talk to you and you don't want to talk to them, then please report that to the court. So with the court's thanks, you'll be excused.
Your Honor, just for the record, and it may be just I misheard, I think it's a challenge by the defense?
That was correct. It was
Okay.
a challenge for the defense. If I stated it another way, the defense raised the challenge. The state did not join or stipulate, and the court ruled on that challenge in favor of the defense's challenge. Next juror we'll bring in is 1323.
Why do they want to be on the juries?
Could we also, let's have them bring in jurors 1210 and 1238 as well. We'll just have them excused so they're not waiting for us to finish. Okay, so we'll have 1323 for further questioning, and 1210 and 1238 are being brought in to be advised that they're going to be excused. All right, thank you. The court has recalled jurors 1210, 1238, and 1323 during this individual voir dire section of the proceedings. We have some additional questions for juror 1323. I will indicate on the record upon further review of the questionnaires and after discussion with counsel, the court understands that juror 1210 is to be excused for the reasons previously stated. Is that correct, counsel?
Yes, Your Honor.
Okay. And then the same with juror 1238, that upon further review of the questionnaire and with the challenge raised by counsel, the court also granted the excusal of juror 1238. Is that correct from the state?
Yes, Your Honor.
From the defense?
Yes.
Okay. For you two jurors then, the court thanks you for your service, the time you've spent here today. I know it's been significant, as well as filling out your questionnaire. As I mentioned to other jurors, if you decide to talk to anyone about this case, be careful to respect the privacy and feelings of your fellow jurors. If you don't want to talk about it and someone insists that you should, please report that to the court. And with that, you can be excused with the court's sincere thanks. Thank you. Juror 1323 is back for individual questioning. In this case, you did indicate some knowledge of this case, so we'd like to discuss that in a bit more detail. I'll have some questions for you first and then allow the attorneys to inquire. In terms of your knowledge of this case, which you do have some as indicated in the questionnaire, can you tell me the source of where you've obtained that information, like what news, if you remember what channel it is? Was it online? Was it through the internet? How did you get that information?
Mainly on Facebook with just like news articles.
Okay. Have you watched any specials such as 48 Hours or Dateline or any made-for-TV movies or documentaries or anything that goes into detail about this case at all?
I think I did watch a Dateline episode years ago.
Okay.
I'm not too sure, but I know that there was a Dateline and I may have watched it.
All right. Thank you for that response. Before I advised you of what the specific charges were in this case, both today and when you got your questionnaire last week, were you aware at all of what the defendant had been charged with, either here or anywhere else?
I knew it was involving two of her children, and those two children ended up dead, so I was assuming it was probably due to that.
Okay. And do you know any more detail about the charges other than what you just said?
No, just those two kids.
Okay. I appreciate your responses. I'll allow for some individual voir dire at this time for the juror from the state.
I'm going to go ahead and stand up so I can see if I may, Your Honor.
Sure.
Sorry, moving slow.
That's okay.
Ma'am, I was looking at some of your answers on your questionnaires. And so it talked a little bit about that you were aware she moved to Idaho to be with Chad Daybell, and her two children were missing and were found dead. When did you learn about that?
It was a while ago. It wasn't recent. I think when it was just really hot in the media. I am from Idaho, so I think when it was all really going really hot with the two kids missing. So I would say when the two kids were missing is when I was aware of it.
So how many Datelines do you think you saw?
I'm not a huge TV watcher like that, so really if I did watch one, and I very well could have, I most likely did not do deep dives into it, but I could have watched one. I don't know how many's out there.
Okay. And do you think you watched one when the kids were missing, or did you see something after kids were found, that sort of thing?
Probably when kids were missing.
Okay. And did you learn that the kids were found?
I did hear that the kids were found, yes.
Where do you think you learned that?
In news.
Okay.
I don't watch TV news, but I am on Facebook.
Okay. And would it have been something that kind of you looked for, or it came up in your feed?
Definitely would have came up in my feed.
Okay.
Yeah, nothing that I would have sought out.
And when the kids were missing, did you join any of the Facebook groups any of that stuff?
No, I did not join anything.
Okay. And how many times do you think it's come up in your feed? More than once? 5? 0?
Probably a few times.
Okay. And since you got your jury summons, have you been on Facebook?
Yeah, I've been on my social medias.
Okay. Has it come up in your feed then?
It's came up twice, but I have not clicked it. I've just scrolled past it.
Okay. Do you remember what those headlines were?
Something with the trial.
Okay.
Yeah.
Okay. Do you know what news sources those came up on?
I don't.
Okay. Do you follow your local TV station on Facebook?
I don't think I follow any Ada counties.
Okay.
Yeah.
Ma'am, I'm going to be really candid. You understand that both sides, like Ms. Vallow Daybell and the people of the state of Idaho, really need jurors who can put aside whatever, information they might have gotten or they think they had and judge the case based on only what's here.
Absolutely.
Okay. Do you think you can do that? Can you put that aside and assure Ms. Vallow Daybell and the prosecutors that you're not going to be thinking about any of those things you've seen?
I really think that I can put everything aside and really just focus on what's presented in the courtroom. I have thought about it this last week, and I'm very confident that I'm able to do that.
Okay. And one of the temptations in high publicity cases is that jurors will kind of be sitting there and thinking, you ever see a movie and previews on a movie, and they show you the previews in the ads, and you're sitting in the movie waiting for the scene you saw in the preview? You ever have that experience? Where you're watching a movie or you're watching something on TV and a preview of an upcoming movie feature shows up. And you sit through the movie and you're kind of waiting for that preview, that scene from the movie come up. Did that ever happen to you?
I don't think so.
Okay. Yeah, I was trying to give an example because sometimes it's a hard idea. The fear is, for both sides, is that while you're sitting there, you've seen something on the news or you've seen some footage on some show, and you're going to be thinking, I wonder when they're going to talk about that. Right?
Okay.
Very human instinct, right? Are you going to be able to avoid that?
I think I will be.
Okay. Remember, I don't remember whether it was Ms. Blake or Mr. Woods who talked about the airplane pilot. I think I can. I hope I can. Can you do it?
I believe I can do it.
Okay. And did I read that right? Do you have your PhD?
A doctorate. Not
Doctorate.
PhD.
Okay.
Doctorate.
In audiology, right?
Correct.
Okay. All right. Thank you. I have nothing further. Thank you, ma'am.
All right, thank you. From the defense, Mr. Archibald, any individual for dire?
And Juror 1323, is it safe to say that when you're reviewing Facebook articles, there's also Facebook comments?
There are Facebook comments. I don't read any Facebook comments because that's just a horrible rabbit hole to get into.
And do you remember any of the Facebook comments about Lori Vallow Daybell?
I don't. I don't read comments.
Did any of your friends talk to you about the Facebook comments?
No.
Your Honor, I appreciate the candor also of Juror 1323 because of the inflammatory nature of the information on Netflix and Dateline. I'm going to challenge this juror for cause for bias.
All right, what's the response from the state on the challenge?
I think the state will not oppose it. We're not going to join in it, but we're not going to oppose it.
Okay, so the state will remain neutral on that. Juror 1323, we are working through these individually. First, as I've stated to many other jurors in this case, there's certainly nothing wrong at all with following the news and keeping up on current events and reading about things that you find of interest. The question is whether or not that should preclude you from service on the jury in this case. I've heard your answers today. I think you've been completely credible with your responses. I've read the responses in your questionnaire also, and the concern that's been raised by the defense, which I will agree with, is there's a pretty significant amount of detail that you did learn from these news stories. Based on that, I think it is appropriate to allow you to be excused based on that challenge from the defense, and so the court will grant the defense challenge as to Juror 1323. Thank you so much for your service and all the time you put in answering the questionnaire and coming in today. As I've mentioned to other jurors, if you do want to discuss the case with anyone, please be careful to respect the privacy and feelings of your fellow jurors, and also limit your comments to your own perceptions and feelings. And if anybody insists on talking to you about the case and you don't want to talk to them, please report that to the court. All right, thanks for your service. You can be excused. We'll next bring in jury number 1370.
Counselor, are you worried about her wedding?
I'm sorry?
1370, are you worried about her wedding?
Well, I tried to get her to say her wedding was important, but she didn't say it.
Okay. I think we would probably join it at this point.
We have a brief sidebar with counsel.
Yes, sir.
Okay, we're back with juror number 1370. The court just held a quick sidebar as it relates to this juror. We're at the point of conducting individual voir dire with this juror. Court, upon discussing with counsel in the sidebar, feels like based on some of the responses on further review in the questionnaire, it would be best to allow for the excusal of juror 1370. And I think that's a stipulated agreement between the state and the defense. Does the state agree with that?
Yes, Your Honor.
Does the defense agree as well that she may be excused?
Yes.
Okay. Well, juror number 1370, we appreciate your time in filling out your responses to the questionnaire and coming in today. Thank you so much for your service. You'll be excused in this case. And if you wish to discuss your service with anyone else after this, please be careful to respect the privacy and feelings of your fellow jurors. Please limit your comments to any of your own perceptions and feelings. And if anybody wants to talk about this and you don't want to talk about that with them and they persist, please report that to the court. With that, you have the court's sincere thanks and you are excused. We'll next move to juror number 1527.
I apologize, Judge. What number did you say?
1527.
I thought that person failed to appear.
That was the juror who didn't show up.
I got their questionnaire still here, but they failed to appear, so they're out. Thanks for clarifying that. It's a welcome sight to see one less on the list for today. We'll be on 1589 next then. Unless they can find 1527, then we'll talk to them. I don't think they're here. All right, thank you for returning, juror 1589. We've got a couple of additional questions for you based on your responses in the questionnaire. It appears you do have some knowledge of this case from prior media viewing. First, I'll note there's absolutely nothing wrong with that. People are certainly free to follow the news as much as they want and read all about every story they want to read. The question is whether or not that would affect your ability to serve here. I'll first ask you a couple of specific questions about that then. In what you've come across that pertains to this case, can you explain to the court what the source of that news or other information would have been? In other words, was it TV? Was it something you read online or otherwise?
It was TV, and I'm not entirely sure what program it was. Maybe it was Dateline.
Okay, do you recall when that was?
3 years ago, I think. Ish.
Okay. Before I listed the charges today that are pending in this case, as well as listing those charges last week when you got the questionnaire. Did you know what the defendant had been charged with here or anywhere else?
I understood it to be murder.
Okay, and what was
Or
the
charged with.
Yeah, do you know what she was charged with? Everything you could remember about that?
I think murder? Or you're asking for specific?
Of what you remembered before, or what you already knew before you came into court for this case.
Yeah, I believe it was murder of 2 children and possibly a husband. Does that?
Okay. Yeah, I just want your honest, candid answers.
I guess
so
to give you context of my confusion, charged with is what I'm unsure of. If there was an official charge or if that was just
versus accused of or something.
Yes.
Okay. And so you indicate you thought it involved the children and maybe what did you say about husband?
Same thing for the husband. There was a disappearance of a husband, I think. I could be wrong.
Okay. All right. I'd like to ask the state at this point if they've got any follow-up questions for this juror.
Briefly, when you talked about maybe hearing of a husband, do you have any idea, where you might have heard that, or a little bit more where that might be, or?
That's why I'm not sure if that was part of the show I watched or if I'm confusing that with another Dateline.
And could you, did any chance you watched Netflix?
I have Netflix. I'm not sure if it was on Netflix that I watched the program.
Okay. Is it possible that it was on Netflix that you saw the program?
Entirely possible, yes.
I think at this point, Your Honor, the state is going to, just in an abundance of caution, keep the record clean. I think the state's going to move for cause.
Okay. Does the defense have any objection to a challenge for cause as to this juror based on that pretrial exposure?
No, Your Honor, no objection.
All right. Juror 1589, I also agree with the challenge based on that. Thank you so much for your answers here today. Thank you for coming in and taking the time to fill out your questionnaire. If you wish to discuss your jury service, please respect the privacy and feelings of your fellow jurors and limit your comments to only your own perceptions. And also, if anyone insists on discussing your jury service and you don't want to talk to them about that and they persist, then please report that to the court. All right, with that, you're excused. Thanks again for your service. Juror number 1658 can be brought in next. All right, juror 1658 is returned to the courtroom for additional voir dire. I'll have a few questions starting out. You made a couple of reference that in your questionnaire that you may have heard of this case. You said you had heard their names on the news and Just News broadcasts. So that's where we'll be focusing our questioning, I believe, including the court's question. Do you recall when you would have last heard about the case in the media?
Is that on?
Yeah.
I'm sure it was probably last week when they said it was coming up. But I really don't listen to the news, so it would have just been a blurb.
Is this something on TV news that you have going in the background or something?
Correct.
Okay. Have you watched any specials, documentaries, movies, anything that focused on this as the subject of those, like a Netflix documentary or a 2020 or a Dateline or anything?
No. No.
None of that? Okay. Do you recall any further detail about this case other than what you've just indicated here and in your questionnaire?
No. I know it was up in the Panhandle.
Okay. If I want to ask you, when I explained the charges in this case, which I did both today and when you got your questionnaire, prior to that, had you heard anything about what the defendant had been charged with?
No. Not specific charges, no.
Okay. That concludes my line of questioning. If the state has any questions for this juror, you can pose those at this time.
Thank you. It's good evening now, so
Good evening.
Good evening. I'm looking at your questionnaire, and I see something that I've heard or seen in the news over the past year concerning the case. So how many times do you think you've seen it?
That would be hard to answer. I'm not a person that watches the 5 o'clock news every day or
Right.
anything like that. So really, the last time I recall was probably in the last week or so, just as one of those blips that come over TV.
And had you seen it before that at all?
I'm sure that I had, but not recently.
Okay. Are you on social media at all? Facebook, Twitter, Instagram?
I have an account on Facebook, but to be honest, I'm not active.
Okay. What do you recall of the news coverage you have seen?
Mostly just that the trial has been moved here, and my understanding is just so that there's a fair and unbiased jury.
Okay. Thank you. I have nothing further.
All right. Vordaer from the defense.
So in your questionnaire, seen the news over the past year. So first time you learned about it was about a year ago.
I really don't know much about it, so in terms of time, I'm just guessing. I just really haven't focused on it.
Okay. And when you learned that you were summoned to be a juror, who did you talk to about being a juror on this case?
Well, after, I really didn't talk to anybody, but after we came Monday and I listened to the judge, then I did tell my boss that there was a possibility of 6 to 8 weeks. But other than that, I really haven't talked about it. I mean, to be honest, there were so many people here that the odds of coming back just didn't register with me.
And so in talking to your boss about it, you're a librarian?
Correct.
And are you being able to be paid if you are selected as a juror?
Yes, we get time off for that.
Okay. And so you're not worried about losing your job if you're selected?
No.
And based upon what you know about the case, are you confident that you can start out with a clean slate with my client?
Yes, considering I don't know that much, I'm absolutely sure I can.
Okay. Is there anything else that you've learned over the past week since you filled out your questionnaire, other than your employment status?
No, I really haven't talked to anybody about it. You said not to talk to anybody about it, so I haven't. I haven't got into conversations about it.
Okay. All right, thank you. I don't have anything else.
Okay, thank you. That'll conclude the individual voir dire. To both, does the state pass this juror for cause?
May I ask a couple more questions, Judge? I'm sorry.
You may.
Thank you. Ma'am, I'm looking at some stuff, and it says you learned the kids' names from the media.
Well, I heard the kids' names from the media, right?
Okay. In a recent news story? Or could it have been one before that?
It certainly could have been one before. I mean, the number 2 sticks in my mind.
Okay.
That there were 2 of them, but actually I really don't know a lot more about it.
Okay. But the names, Tammy Daybell, Tamara Daybell, Tylee Ryan, or J.J. Vallow, stick in your head?
I guess so.
Okay. I'm just reading your questionnaire.
Right.
It's like, I have heard their names on the news,
Yes.
right? Yes. But you don't know when you heard that?
Well, I'm sure probably last week, as there were, it was covered, and I'm sure probably in the past, but I just haven't followed it or delved on it or.
Do you remember last week? Do you remember what day it was that you watched it?
It would probably been the middle of the week. I don't think it was Monday.
So
I was here, but.
Right. So maybe after Monday you saw the news story on it?
Probably.
Okay. And it just came up on the news and you watched it?
I heard. I don't sit in front of the television and watch the news, so.
But you heard it.
Like moved around.
Yeah. Judge, in an abundance of caution, the state's going to move. That would have been after Monday. And so the state's going to move for cause.
All right. Any defense or any objection as to this juror?
No objection, Your Honor.
Okay. Well, the court's considered the responses here as it relates both to pretrial publicity and the court's admonishment. With the state making the motion and there being no objection, the court will grant the challenge as to this juror for cause. So juror 1658, with the sincere thanks of this court, you may be excused. If you decide to discuss the case with anyone, please be careful to respect the privacy and feelings of your fellow jurors and limit your comments to your own perceptions and feelings. And if anyone persists in discussing the case over your objections, please report that to me. Thank you so much for your appearance today, and you can be excused. We'll call in the final juror 1758 for this group. It's 1658. Yeah, sorry. Yep, 1658. Yeah, I guess those two are like 100 off. They're the same. All right. Juror number 1758 has returned for individual voir dire. Thank you for your patience. I know it's been a long day. I think on this one, we didn't have a pretrial publicity issue. It was something else the parties wanted to discuss. So does the state have any individual voir dire for this juror?
I do think it's a pretrial publicity issue, at least in part, page 11, question 2. And so I can proceed if you want me to, or does the court want to do their regular?
Okay, thank you for directing me to that, Ms. Smith. There is some indication that you had a prior exposure to some media somewhere in this case and some knowledge of the case. So let me ask, first of all, before I explained what the actual charges were in this case that I explained today and last week, had you heard at all about anything about this defendant being charged, or no? Did you know what she was charged with anywhere, including here?
I've heard people talk about the case because obviously it's pretty popular, but as far as learning any of that through media sources, I hadn't been exposed through the media, just people around me talking about it.
Okay, and with what people around you talked about, did you hear anything about her being charged with anything before I explained that to you when you were here?
No.
Okay. Did you ever view any kind of documentaries or news specials like a 2020 or a Dateline or anything like that that deal with this case?
No.
Okay, when you talk about the people around you that have been talking about the case, could you just explain who that is? The nature of your relationship with them?
Primarily just coworkers. You know, it's the small talk.
All right, at this point, that'll conclude my line of questioning. If the state would like to follow up, you may.
Ma'am, you're a paralegal?
Correct.
Okay. And so when your colleagues were talking about this do you work in a commercial real estate office, or do you work in a law firm?
It's a commercial real estate company, and I work in their legal department.
Gotcha. So when your colleagues were talking about this, what was prompting sort of that water, I always call it water cooler, I'm probably aging myself, but that water cooler conversation, what was prompting it?
It was mostly just with the trial coming up, they knew about it, and then I just mentioned that I would potentially be out for 8 weeks, and then they're like, oh, is that what you're doing? I'm like, I can't tell you. And then, of course, they just prattle on with whatever that they were talking about, and I wouldn't say anything and would exit the conversation.
Gotcha. When was this conversation?
It would happen within the last week or so.
Okay.
But I wouldn't entertain any of the conversation.
Got you. And had that occurred sort of after last Monday?
Yes.
Okay. Had you heard about the case at all prior to that?
I had heard about the case a couple years ago. I think maybe in the questionnaire I put 2018, 2019. And I think I was stuck on COVID time. It was probably more 2020.
Okay.
But I think at that time stuff was coming out. So again, where I was working at the time, coworkers were talking about it. But I don't really remember any of those details.
Where were you working a couple of years ago?
A couple years ago, I was in Salt Lake earning my paralegal degree, and I was working at a law firm down there.
Okay. What type of law firm?
Multiple areas of practice. It was a pretty big law firm.
Okay. And what was prompting the colleagues to talk about it then? Was there something going on TV? Was there something Netflix, Dateline, 2020?
I don't know specifically. I think sorry for talking.
No, it's all right.
I don't know specifically. The receptionist that they had was super into following it. So every time I passed her, she's like, "Did you hear it?" I'm like, "No," and she would tell me whatever she learned. But that was been a couple years ago now, and I don't remember what she told me.
Got you. And do you think her source of information was any of the prominent shows or anything?
I honestly have no idea.
Okay. Do you have Netflix?
I do.
And did you ever see anything run on Netflix?
Nope.
Okay. How many times do you think that you had that conversation with that receptionist?
I'm sure she brought it up multiple times, but I'm not the type of person to base my opinion on what other people tell me. And because of the kind of cult almost that's surrounded, whenever anything's a big news story, that kind of made me less interested. So I didn't bother to research it myself, and I just, entertained the conversations at the time and moved on.
Gotcha. And And then your colleagues at the new place brought it up again.
Yeah, within the last week. Just, I'm sure with the anticipation of the trial.
Gotcha. Did they know you'd been summoned?
Yes, just to communicate my absences.
Okay. But they brought up the case and about it?
Yeah.
Your Honor, I think in abundance of caution, the state's going to request this juror be excused.
All right. Does the defense have a response? Okay.
To that challenge.
The court's reviewed the challenge of the state brought up an individual voir dire. The court will grant the challenge based on responses made in the individual voir dire. To be clear, I appreciate you following the court's admonishment and not engaging in those discussions with your coworkers. You can't control who comes up to talk to you.
Right.
However, some of the questions about prior potential knowledge, I think, could serve to potentially confuse the evidence in this case, and I find good cause to grant that excusal. So juror 1758, you'll be dismissed in the case. Thank you for your service on this day as well as last week when you filled out your questionnaire. If you wish to talk about the case with anyone, please respect the privacy and feelings of your fellow jurors. Limit your comments to your own perceptions, and if someone persists in talking to you and you don't want to talk to them, please report that to the court. And that'll conclude your service. That goes through the questionnaires, and then, so what do we have, 2 that remained from this, or 1? Is that 1133? Okay, let's have 1133 brought back in, and we'll.
Judge, may we go back into simulcast?
Yes.
Judge, we're ready.
Okay. We'll go back on the record on case CR 22-211624, State versus Lori Vallow. We just completed the individual voir dire questioning of this last group of jurors. There's only one remaining juror after challenges for cause and other excusals for hardship, and that's juror number 1133. So to make the record clear there, from the state, does the state agree that juror 1133 is the sole remaining juror out of this group? Yes. All right. Could you put that on the record, please?
Yes, Judge. That's our understanding is 1133. May we approach briefly, Judge?
Yes.
Thanks. careful. I moved this chair.
Yes.
I started to do that like this.
We're good, Judge.
Okay, we are returning on the record on this case. We're completing the voir dire of this group of jurors. The remaining juror was 1133. Court just had a sidebar with counsel. Upon further review of some of the answers in the questionnaire and noting that the defense had initially lodged a challenge to this juror based on the questionnaire responses when we put those on the record yesterday, it's determined at this point that the state does not object to the defense challenge raised on the record yesterday. Does the defense still maintain the objection you made on the questionnaire when we went through those, Mr. Archibald? Does the state have any objection to the challenge of the defense on juror 1133?
No, Your Honor.
Okay. Well, based on that then, juror number 1133, the court will excuse you for cause for reasons stated on the record during the review of the questionnaires. The court very much appreciates your time in coming in today, completing your questionnaire. If you wish to discuss this case with others, please respect the privacy and feelings of your fellow jurors and limit your comments to your own perceptions and feelings. If somebody wants to discuss this case with you over your objections, please report that to the court. And with that, that will conclude your jury service for today. All right. Once this juror's been excused, I'll briefly address the parties before we adjourn for the day. All right, that concludes the individual voir dire for these three groups. We will take our evening recess. Obviously, we went quite long today. It's not going to be my practice to try to run days this long. That's just how it worked out for the day. We have three more groups scheduled to go through tomorrow. I think we're improving a bit in the efficiency and hope we can get that sorted in within regular operating business hours. I appreciate the patience of the courthouse staff who has worked a long day today, including after time. And unless anything else needs to be addressed at this time, we'll adjourn for the evening. We'll commence with our next group of jurors starting at 9 o'clock tomorrow morning. And the parties have been given copies of the list that will come up first thing in the morning. So anything else we need to address on the case before we adjourn from the state today?
Okay. We just don't have the list for tomorrow.
Your Honor, there's a bit of confusion. We have the list for tomorrow?
We have the groups that are coming in at 9 and 11.
9 and 11,
We
okay.
don't have the 2 o'clock group, correct?
We don't have the afternoon
gonna
one
get a
yet
copy
set
of
up.
that?
We'll have that to you either later today or by tomorrow morning when we start.
So will that be by email? Oh.
We've got it.
Okay, excellent. Thank you.
My staff attorney's been working on that, so we'll get you a copy before you leave tonight.
Thank you.
Anything else from the defense this evening?
No, Your Honor.
Okay. Thanks, everyone, for your hard work today. We'll see you in the morning, and we're adjourned for the day.